Good evening. This is John Milburn for Laws 12062 Alternative Dispute Resolution. We're into week 9 of term 2, 2017. And the topic for tonight is legal issues. It's based on chapter 8 of your text, David Spencer. Before we get into that, just a couple of things. The first is that the first assessment, which is the assessment involving your ADR session, is a difficult one for me to mark in that it takes a long while to go through each of the mediations and to provide some comprehensive feedback. I quite often need to look at the videos 1 or 2 times. So it does take a while. My commitment to you, as is always the case, is to have the material back by the Sunday or Monday of the week following the day that you lodge it. So typically material lodged on a Thursday, and I have it back to you Sunday week or Monday week. I expect to be on track to do so, but if I am late, please excuse me because of the nature of the assessment. The next thing is that this week is feedback week. You're in second year, so I'm sure you're aware of the feedback icon, the big red button at the top left-hand corner. We'd certainly appreciate if you would contribute your thoughts in that regard. And it's helpful to me, it's helpful to the university. So tell me what you think about the course, the way it's delivered, the assessment regime. Is it a fair regime? Is it comprehensive? My aim is to produce something which is actually useful for you in practice, and I reflect the assessment in that manner. Well, soon we'll be talking about the take-home paper, and I haven't delivered the take-home papers that I set last year and the year before to you, have I? The year before that, as I recall, it was a different assessment regime. Have you seen the assessments that take home from last year or the year before? Probably not. Well, I might release those to you in the next couple of weeks and then we can discuss it from there. One thing that I will ask you to do is ensure that before we get to that stage, you are well and truly aware of how to reference your material. You've all seen, I think, in the material that I have provided, that I'm very keen on the presentation. I'm very keen for you to ensure that you undertake legal research and that you reference your material well. Just on the topic of legal research, when it comes to the take-home paper, I would expect that you'll be able to produce material that is sourced from other than your textbook. So the text is excellent, but it's quite thin, quite easily read, and I would expect you to go beyond that text in terms of reference material. When you do refer to material, make sure that you follow the Australian Guide to Legal Citations. If you're not aware of AGLC 3, then please become aware now. There is plenty of good material. If you're struggling, make a post on UCrew and we'll see if we can provide you with some summaries. So footnote referencing, we're all familiar with that. We don't use endnotes. You don't have to put in a bibliography or a contents page, but you can if you wish. The material that is in the footnote does not form part of the word count for the take-home paper, nor does a bibliography or a contents if you choose to go that way. But that's not prescribed. Make sure that anything that you reference in the footnote is completed with a full stop, and any footnote numbers should appear after the relevant punctuation in the text. So that's rule 1.1.2. In other words, it might be sentence, comma, and then you put in the footnote reference, ends, full stop, and then you put in the further footnote reference. So after the punctuation. Single quotation marks to indicate short quotes. Quotes of more than 3 lines should be indented from the left margin without the quotation. So we're talking, hi Tamara, we're talking about the examination, but in very general sense at this stage, only talking about the Australian Guide to Legal Citations. Make sure that you put italics, text where relevant, and you should be aware of how to use, say, IBID in referring to a source immediately preceding the footnote that you're referring to. That's rule 1.4.1. Cases, make sure that where possible you refer me to the authorised report. The authorised reports are essentially the Commonwealth law reports, the federal court reports, the Queensland reports, for example, in Queensland. The non-authorised reports are only to be used if you can't source a reported version. You access the reported versions where? Can anyone remember where we find those? All right. Essentially, Westlaw and LexisNexis. Now, I assume that all of you have access to the University Library, online legal library, and you know how to use it. If you don't, if you're genuinely struggling, if that's something that wasn't a big part of what you did in first year, it's something that I like to stress, and I can provide some additional material or assistance in that regard. Okay, so that's just a brief guide as to what you now start to need looking at for the examination. We'll go into more detail over the next few weeks. Okay, topic for tonight, legal issues. The first is confidentiality. As many of you identified when doing the first assessment, confidentiality in an ADR process is critical. It's one of the hallmarks of dispute resolution in ADR. So confidentiality is used as a hallmark to encourage people to make concessions, to extend offers, and do so in the safety of knowing that that can't be used against them in later court proceedings. Essentially what we're doing is we're allowing the parties that freedom to express themselves in a way that will enhance the prospects of a successful negotiation. But what if someone deliberately withholds information, then discloses that information during an ADR session and thinks, well, now that can't be used against me, even though it's material that should have been used or disclosed to the other party during the course of the litigation, or will be used. So just bear in mind that ADR procedures sometimes can be used by parties to try to work around the appropriate system and act in an inappropriate manner. Just something to think about when you're doing your reading. And as always, when you're doing your reading, I'm very keen for you to do so actively, in the sense that you're asking yourself, how can I use this section or case or commentary in providing a response to a problem? What you can be almost assured of is that the exam won't be requiring you to list 10 reasons why you might go to mediation, for example. You know, it won't be sort of an essay style question. Typically, I set problem solving questions. So with that in mind, when you're reading the material, think about how this is likely to be applied in practice. Okay, what if we have a situation where an agreement is struck at mediation and there is a failure to comply with the terms of that agreement? Can a party enforce an agreement that was struck during a mediation session? Any thoughts? Tim says no. Would a party therefore logically say, well, what's the point of going to mediation if the ultimate aim of the mediation is to have a resolution of our dispute and reduce that to writing? Is the written agreement that is struck at the mediation simply an option for parties to consider enforcing if they wish? What do you think, Tim?
Well, I'm thinking about family dispute resolution and parenting plans that aren't binding on parents, and it really relies on the honour of and good faith of both people to do what they say they would do.
What if during the course of the mediation, instead of a parenting plan, the parties were legally represented, and as a result of the agreement struck at the mediation, the parties, through their lawyers, prepared and presented to the court a consent order, so that the court then made an order reflecting the agreement? Is that enforceable?
Yeah, that would be binding.
Okay. All right. So in family law context, there may be a difference in relation to enforceability. What about in other areas? Let's say we have a dispute involving, say, neighbours over a fence. They go to a mediation, they come to an agreement, they sign the agreement, and then one of the parties says, no, I've changed my mind the next week. Is that agreement enforceable? All right. Conveniently, I'm not going to give you a lot of answers, but what I want you to do is read the material critically, thinking this could be an exam question. Think about whether there are any statutory exemptions, and think about whether it makes a difference if the agreement is one that is reduced to writing, one that's reduced to writing with the assistance of lawyers on one or both sides, one that is made into some form of court order and becomes the subject of a court agreement. So think about it at different levels. Now, what if we have this situation where in a mediation session there's a concession made or a statement made of fact, which is an honest reflection of the true position, the facts. It doesn't settle, and then next week in front of a judge, your opponent, either directly or through a lawyer, says something to a court that is clearly factually incorrect. And they're absolutely telling the court something entirely factually different to what you know to be the case through their concession during the mediation. Can you then disclose to the court something that was said by the opponent during the mediation? Again, have a think about that and ask yourself, particularly in the context of any statutory exemptions, whether there is an exemption to that general duty of confidentiality and non-disclosure if to do so would provide evidence to a court to counter misleading evidence to the court. Maybe that's an exception. Okay, let's talk about it. Yes, Pajan?
Sorry, before you move on, when you're saying that, are you saying that the court will accept the evidence of the agreement, or are you asking us to question if it could go in?
Yes.
Just to clarify.
I'm being really difficult tonight. I'm posing questions and not necessarily providing answers.
Okay, so if hypothetically it was, would that be in relation to the Wentworth and Rogers case, or no? Maybe.
Yeah, I'll have to refresh my memory on Wentworth and Rogers. What do you say?
It just looking over it, because I'm just reading the notes. It was it questioned if mediation agreements enforced in court, if the court would not admit the agreement into evidence, and that was what essentially the case was about. How it to overcome the amendment.
Is it in the text? Is it one of the cases?
It's in the study guide on page 12.
Oh, okay. All right. Thank you. No, I'll have to look at that again. Sorry, Pajan.
Yeah.
Thank you for raising that. Okay, so that's exactly the sort of thought. Spencer 262 says, Karen, thank you very much. So that's the sort of thought process that I want you to consider when you're reading the material. What if we have this situation? What if there is an agreement struck at mediation in relation to certain aspects of the case, but not other aspects, and there's an argument about legal costs, or maybe an offer that was made at mediation, and the parties say, well, if you'd accepted that offer at the mediation, that was actually better than you got during the court, so why should I pay your legal costs when you've incurred greater legal costs by going to court than you would have had you accepted the better offer that I made at mediation? Why should I be penalised you're the one that's gone to court. You got a worse deal than I was offering. So why should I now pay your costs as well? So think about that aspect as well, and whether there's any aspects of costs that may have a bearing in that issue of confidentiality or a statutory exemption to it. Have a look at the, say, Calder Bank case. When we're talking about ADR, bearing in mind that there's a wide range of ADR processes available, do we consider dispute offers that were made without prejudice as part of an ADR process? My personal view is I think we can. So you're familiar with the without prejudice regime. It's essentially where a party extends an offer, typically through lawyers, to another party, but marks it confidential, and the typical wording is without prejudice, or perhaps without prejudice save as to costs. So the idea of the without prejudice correspondence is that it's not to be used in court, but it does provide an opportunity for the parties to try to resolve the matter without being in a formal ADR session. So there may be some issues about overriding the privilege for without prejudice communications in much the same way as we do for ADR processes. So think about whether parties that might engage in misleading or deceptive conduct have waived their right to privilege in circumstances where they now try to approach a court in a way that you say is misleading or deceptive. Also, it may be that through the without prejudice communications, we have a contract. So it comes back to that same sort of ADR process. If we have a contract in ADR, or we have a contract as a result of exchange of without prejudice letters, can those things be raised in later court proceedings? And you might ask yourself, while there is a public policy to ensure that confidentiality is available during ADR process or without prejudice exchanges, is that something that is always subject to a rule that the court should not be misled? Or if there is a contract, parties are entitled to enforce that contract. And there may be a dispute as to whether this communication, which is said to be without prejudice, is genuinely to do with settlement negotiations. Have a look at the decision, I think it's in your text, of Field against Commissioner for Railways, and that deals with communication that is not truly to do with settlement negotiations. So just on this topic of without prejudice communications, it generally only applies to civil litigation, and it covers all sorts of admissions that may be made. It's not restricted to communications by lawyers, but typically it is by lawyers. Just on that point, if you do some additional research, I don't think it's in your text. It's a case of Rogers, RODGERS, against Rogers. It's 1964, 114 CLR at 608. And this is a case in the family jurisdiction where, prior to the Family Law Act, but prior to litigation, a couple spent a considerable amount of correspondence between themselves and through their respective solicitors. During the communications, the husband disclosed considerable detail, and the court held that the family court should not have used that information in making an award to the wife. Even though the parties had not headed the communication without prejudice, they were clearly trying to attempt a settlement, and what the husband disclosed should have been regarded as confidential. That's still good law, but it's law that I question, and it's law that I think will eventually be overcome. So we're talking about without prejudice communications. We're talking about that as a means of alternative dispute resolution. We're talking about the extent to which that and mediations and other agreements can be privileged and not enforced. Have a look at a decision of Walker and Wilshire It's 1889 23 QBD 335. You're saying, how do we find QBDs? Well, that's English decisions. So you'd look in lexis.com, not LexisNexis, but lexis.com in your library if you want to do that. Or you can just read some general commentaries about Walker and Wilshire. If the proposed terms of a without prejudice letter are accepted, then a complete contract is established, and the operation, the letter which is headed without prejudice, once it's accepted as an offer, operates to alter the old state of things and establish a new one. So that's a decision that might assist you in your arguments if you're trying to promote an argument that an agreement at mediation is actually enforceable even though the mediation session was without prejudice. Does that make sense? So it's really an extension of that principle in Walker and Wilshire that you would promote. And I've mentioned the case of Calderbank. That's Calderbank and Calderbank. You really want to know this case anyway because it's critical on the issue of costs. It's an English decision, 1995, 3 All England, that's All ER, 333, and it's called Calderbank. And essentially what Calderbank is this: one of the parties in a without prejudice letter reserves the right to refer to that communication in future dispute about costs. So it might be produced in those circumstances, and a Calderbank offer is usually headed without prejudice save as to costs. So it's that argument that's used to say, well, again, you knocked back this offer on day 20. On day 220, the court gives a decision which is less favourable to you than what I offered in the without prejudice correspondence on day 20. So why should I pay all the legal costs from day 20 through to day 220? That's what Calderbank's all about, and it's really important in practice. But it fits within this general enforceability of without prejudice or privileged or confidential, if you like, communications in the same way as they do for ADR. If you're looking at a section, have a look at the Commonwealth Evidence Act, section 131, and that talks about evidence not being adduced of a communication made by people in a dispute regarding an attempt to settle the dispute, or a document prepared regarding an attempt to negotiate a settlement of the dispute. But there are some exceptions in section 131 that you may need to consider and argue about. One is that it doesn't apply if the parties consent, or the substance was disclosed anyway, or it tends to contradict evidence, or to enforce an agreement, or to avoid misleading the court, or relevant to costs or fraud or an abuse of power. So there's a whole range of exceptions. Now that's the Commonwealth jurisdiction, but it might be something that you can use to enforce your position if you're in a position where you want to enforce an agreement, or argue that something which would otherwise be confidential is appropriately introduced as admissible evidence. So the general rule is, no, it's not admissible, but there are some exceptions, at least in the context of evidence of exclusion of evidence of settlement negotiations. So what we're talking about in some way is privilege, and this now gets into the area, and I'm digressing a bit here, but legal professional privilege, and that attaches to certain communications or documents. And there's a decision about arbitration in that context. So this is really coming back to legal issues and ADR. In the context of whether legal professional privilege attaches to things said or done in arbitration, have a look at SO Australia Resources against Plowman, PLOWMAN, 1995, 183 CLR 10, and in that case the court was not prepared to imply a term of confidentiality in relation to information disclosed during arbitration, which is perhaps not surprising in the sense that arbitration, although it is one of the 14 types of ADR identified by Spencer, it's the most court-like, it's number 14 in terms of the formal non-consensual or interventionist aspects of it. Now, there are some statutory provisions to look at. One is the Queensland Civil Procedure Act, and just bear with me a moment. Yeah, Section 36 of that Act is useful in terms of considering the extent to which statutory privilege will apply. Okay, so that's all that I want to talk about tonight at this stage about confidentiality and legal issues. Let's just move on to another issue of liability and immunity of an ADR practitioner. So you're an ADR practitioner, you've conducted a mediation or an arbitration, a case appraisal, a conciliation, an expert matter. So can you be liable? Well, potentially you can. One of the areas where you might be liable is in contract, because as an ADR practitioner, you're entering into a contract with the participants. Another area where you may be liable as the ADR practitioner is in torts, negligence. One of the parties may say, you had a duty of care to me and you breached that duty of care, which has now caused me to suffer actual loss or damages. But of course, the plaintiff in those circumstances would need, like in all negligence claim, to establish a causal connection between the negligence and the loss. However, the reason I'm raising that is, as an ADR practitioner, it would normally be incumbent upon you to prepare the mediation or conciliation or other agreement with the participants. And when you're preparing that contract, any drafting will be construed against you, so you need to be careful and accurate with it. So if you had an exam question that dealt with the issue of potential liability that you may suffer under contract or tort, think about whether you can build in some protections and think about whether you have any form of statutory immunity. When it comes to this, in statutes in Queensland for arbitration or mediation or ADR generally, think about the Civil Proceedings Act of 2011. Think about think about the Commercial Arbitration Act, and think about the UCPR. I think we talked about that last week. All right. So enforceability of settlement agreements we've touched on. Ask yourself whether the law of contract applies, and ask yourself whether it makes a difference if the contract was just simply in writing signed by the parties, or maybe if it was a deed, or maybe it was a consent order. And if you're trying to do the opposite and you're trying to set aside the agreement, think about whether that's possible and what type of evidence you would need. So let's have a situation where a person in a mediation says the week after the mediation, I signed the agreement, but I was forced into it, or I was suffering lack of sleep, or it was unconscionable and it was unfair because the other party was represented by legal counsel and I had no one to help me. Think about those issues and think about it in the context of trying to enforce the agreement, set aside the agreement, and your potential liability as the ADR practitioner in the middle. Okay, let's go back a step and talk about the enforceability of dispute resolution clauses. So let's assume that you have been engaged by a client to prepare a contract, and in that contract you made provision for the obligation on the parties to proceed through ADR before they go to court and litigate. So have a look at Scott and Avery, what we call a Scott and Avery clause, where the parties may agree to, by contract, to involve the dispute resolution process as a condition precedent to litigation and the issue of whether the parties may contract to oust the jurisdiction of the court. So there's a whole range of cases in your text. Have a read of those. I'll draw some of them to your attention. The first one, where the courts adopted, I think, a pretty hardline approach, was the decision of Elizabeth Bay Developments against Boral Building Services from 1995. So I'm sure that's in your text. Essentially, it said that the court considered the ADR clause. It was detailed. They referred to 2 external documents that were not annexed to the contract. The external documents were inconsistent with each other and the clause, and the guidelines in the appointment agreement did not create sufficient certainty in the process. So the parties had to agree on mediation appointment without agreeing to its terms, and it was held to be unenforceable. So Elizabeth Bay is an example of where the court had a pretty hard approach to the mediation clause. Similarly, have a look at Alton, ALTON Australia, against Transfield, 1995. Again, a hardline approach. The mediation clause was found to be uncertain. The mechanism for appointment of mediators' costs was not clear, and that clause was not severable from the negotiation agreement or clause, so it was struck out. So, what do we glean from that? You read those 2 cases, and you could conclude that the parties actually have to set out a detailed procedure, and they have to build in the ADR process in the contract in order to evidence the requisite intention to be bound by that process. If we look at a more moderate approach, have a look at Computershare against Perpetual Registrars. It's from 2000. Again, it's in your text. And the court found that the agreements to negotiate were capable of being enforced, and there was a clear intention of the parties to, if you like, to enter into that prescribed process. And finally, have a look at United Group Rail Services against Railcorp from 2009 in that regard. So if you're going to draft an ADR clause, one that compels the parties to go to ADR before proceeding to litigation, I guess as a minimum you need to ensure that there is a remedy for a breach, and you need to ensure that there are clear processes in the clause that you've drafted. All right, that's all I propose to talk about for the legal aspects and issues for tonight. Think carefully about what you're reading, and be prepared to go beyond the reading to look at, say, legislation. Any questions about that? All right. What I just finally want to talk about tonight is something that follows on from the assessment, something that is really important, I think, for you to prepare as part of, if you like, a toolkit, if you're an ADR practitioner, and that is the strategies that you might employ for assisting the parties to break deadlocks. There's a whole range of things that you could do. This might be examinable. So you'll remember that I said that your aim in an ADR session, in some ways, to borrow from Professor Adrian Ashman of the QCAT, is, have you become the party's new best friend? It's simple, but if you can connect with the parties and they trust you and they're willing to work with you, that in itself is a really good way of breaking deadlocks. So if you're finding that in ADR you're not assisting the parties to break deadlocks, ask yourself, did you make a real connection with the parties, and did you demonstrate understanding of their position? Because understanding their position is always a good way to assist the parties. Ask yourself, did I create a safe environment for the parties? I mentioned before, you might find a party says, I entered an agreement, but I was forced into it, so it wasn't really a safe environment. Likewise, that might be the reason why the party is refusing to enter into agreement. They don't feel safe. They don't feel that there's a degree of protection in that regard. So having good communication between the parties and assisting them in a safe environment is important. So think about how you might go about preparing strategies to break deadlocks. I've got a whole range of things that I've got in mind, but I won't disclose them because it might be an exam question. And I want you to think about it from your perspective. And think about it in the context of a mediation didn't settle, and the next day you think to yourself, why couldn't I assist the parties to break that deadlock? I mean, it really was in their best interest if they both gave something. Is there something I could have done better, which I didn't do? I know that's a very vague statement to make, and I've given you some hints as to what you might put there. Can you think of any other things just off the top of your head that on reflection you could ask yourself, did I do this or did I fail to do that? In the context of not helping the parties to break a deadlock. Any thoughts? Yes, NASA?
Yeah, John, it's much easier to break a deadlock when you're a conciliator because you can make suggestions. Whereas as a mediator, you sort of like, sort of balance their conversation and summarize their conversation, but without making any suggestions. So I'd say it's much easier to make a suggestion as a conciliator because you're allowed to do that.
Yep.
It's easier to break a deadlock.
So in the context of that possible exam question that I've mentioned, you might, on reflection, part of your strategy might be, as an ADR practitioner, in future, I will promote conciliation ahead of mediation as a preferred model for dispute resolution. Is that kind of what you're thinking, NASA?
Yeah, definitely.
So again, we're thinking about the day after, the week after. Why didn't that settle? Why couldn't I assist the parties to break that deadlock? I've mentioned a few. NASA's mentioned one. Any other thoughts?
Yeah, John, in relation to mediation, perhaps you didn't identify the common ground to assist the deadlocks, etc.
Yep.
Perhaps you could have done a bit better in the common ground area.
Yes. And creating the common ground is really important. Thank you for that, Steve, because it gives people a chance to have their say. And very importantly, it gives the parties a chance to listen actively to each other. And maybe what you need to do upon reflection is to be better at asking exploratory questions and setting the facts and then getting an agreement on those facts so that you're layering the situation, so that you're saying, all right, we're agreed on this aspect, we're agreed on that aspect, we're agreed on that, and you're layering it to the point where the real dispute becomes apparent. And what you don't want is a situation where one party is sort of thinking at this level, the other party is thinking at the other level, you haven't got that layering of common ground and haven't made made the parties come to an agreement about certain basic things. Thank you, Steve. That's good. So that might be a good thing to reflect upon after the event. All right. Again, I won't go into any more than that, but it may be that as part of your toolkit for ADR practice, in reality, you want to have a series of questions ready to go so that you're thinking, well, why didn't that settle? Maybe I just wasn't quick enough. And it might be that the next day or the next week you think, oh, if I'd thought about that technique, or I'd thought to ask that question, then maybe things would have been better. So I'll write that question now and have it ready for next time. So what I want you to do is think about that list of things that you would have for the hypothetical next time, if you understand what I mean. And it might just be a series of questions. I mean, one is maybe, have you consulted experts? Depending on the nature of the dispute. Have you considered the cost to you in your personal relationships of not settling? Kind of one of the whatners. Is the danger that if you, and this is just a question that you might pose to the participants, but have it there ready to go, is there a danger that if this matter is ultimately resolved and not settled today, you might look back on today's events and ask yourself, why didn't I settle then when I could have settled, instead of getting all the way to day 220? Why didn't I settle on day 20? So maybe ask that question of the participants on day 20. Is there a danger that you will look back on this day and say, why didn't I settle? And if you invite the parties to reflect upon their choices at the mediation session, it puts them on the spot a bit, and sometimes that will work. But you've got to have these tools ready to go. You can't think about the week after. All right, so they're the sorts of things that you might want to start thinking about actively now in creating your own little toolkit for techniques, and more particularly questions, that you would ask of the participants in trying to assist them in breaking a deadlock. I hope that's been pretty clear. Clear as mud? All right. And it just occurred to me in looking at the videos that there were some times where there was a deadlock, and I'm thinking to myself, if I was there, this is a question I would ask, and I didn't always hear it. Okay. All right. So a bit of a mixture of things tonight. We're starting to look forward to the take-home exam, and I will have the results of the first assessment to you pretty soon. Any questions, comments before we take an early mark? All good? All right. Thank you for that. I'll end the session now, and thank you for attending.